You've been asked to watch this video because your deposition's coming up. And the video is designed to give you a bit of an introduction to what a deposition is and some few basic tips before we do some specific preparation together. I found that the majority of depositions that I've prepared into people for start out with a lot of the same basic things, so I decided to put that into this video to cover that so that you can do that wherever it's convenient for you, and then when we work together we can focus on the more specific things. First of all, what's a deposition? A deposition is a recording of sworn testimony that can be later used in court. That recording is usually done with a stenographer or a videographer or audio recording. So it could be either videotaped or just taken in shorthand by a court reporter. Now, any of those things can be used in the courtroom to present your testimony to the jury or finder of fact in the case. I say finder of fact, that could be a judge or the jury. The people that can be deposed are the parties, that's the plaintiff, the defendant, or witnesses to the facts of the case. That could be either people that actually observed the event or observed some of the things that had to do with maybe, for example, the medical treatment that was done in the case. The people that can ask for a deposition are the parties to the case. That's the plaintiff, the defendant typically. Lawyers for those people will notice that deposition at a specific time and place, and they're to appear and give that testimony. And all the lawyers in the case, or all the parties in the case, can ask questions of those witnesses. Lawyers can't coach their clients' testimony during that deposition, and the attorney's ability to object to certain questions is limited in that deposition. So these are some of the things that I want to go over with you to give you kind of an outline of what you might expect and how to deal with those types of questions. Now, you might hear a few terms, and I've already mentioned a few of them. Witness, party, deponent, objection. Witness is just the person who's been called to testify or give the evidence in the case. A party refers to either the plaintiff, the defendant. There are other types of parties that can be in a case, but for the most part, you're going to hear the plaintiff or the defendant. The deponent is the person who's being deposed. So you could have a party deponent, meaning the plaintiff or the defendant being deposed. Sometimes you hear it as a party witness. The plaintiff is the witness being deposed, or the defendant is being the witness deposed. Any one of those interchangeable terms are things that you might hear. The other thing is an objection. You've probably heard the term objection. Objection is simply the reason in support of a party or that party's attorney's claim that the matter or the proceeding is improper, or the question that is being introduced into the matter of the proceeding is improper. It's the reason for that complaint. Before we get into that, though, we have a few goals for our deposition, as that is testimony that you'll give, not the deposition that I'll be taking later. First and foremost is to give honest testimony, to tell the truth, and that definitely sounds simple, but there are a few caveats to that are not as obvious, and of course we'll get to those too. Second goal is correctly stated testimony, making sure that the things that we tell the other side, or the things that we put into the evidence, because this is sworn testimony, that it is correct, and it's not something that can be interpreted incorrectly or is ambiguous, to the best of our ability. Third goal, no more testimony than necessary. We want to make sure that the question that is being asked of us is answered, but it's not our job to go and explain the answer to our question without some other question from the other attorney. I've heard it said that if the other attorney is smart enough to ask the question, they're entitled to the answer. We don't want to be helping them to be smarter than they really are. And finally, the fourth goal of our deposition goal is to comply with the rules. And I'll go over the rules for you. Those will be easy. That's mostly my work in this, but the most important thing for you to remember is that you're to answer the questions that are being put to you honestly, correctly, and with no more information than is asked of you, unless you've been told otherwise. A couple things to do to be a great witness, and these keep in line with what our goals are. Understand that the person taking your deposition, typically a defense attorney, will be reporting back to an insurance adjuster who will have questions about how the deposition went. and we want them to be able to report back to the insurance company or the insurance company's adjuster that you are a great witness, and that'll help our position in the case for negotiation, usually at the mediation or before we get to a trial. So in order to be a great witness, you need to tell the truth. You don't need to be guessing about answers. That's sometimes when you guess about something, you aren't telling the truth. If your brain fills in some gap and your brain has filled it in correctly, then that might be a lie. You need to be able to deal with leading questions. Those are things that the other side will ask you to adopt, and if those aren't true, I don't want you to feel like you've been forced to answer something, because you can say yes or no. Fourth, you need to make sure that your answers to the questions are responsive. That's a really important one, and I think a lot of the time people will be in that situation of the deposition, and they'll give testimony or they'll answer questions, and they'll continue to talk because they're uncomfortable. I want you to be really careful to understand the question that was asked of you and make sure that the answer that you give just answers that question and does answer that question. I want you to keep a good mental attitude. You understand that you're at the deposition. You have to be at that deposition if you want to continue your case. The deposition could be a positive opportunity for you to influence the outcome of your case. That is, if you are a good witness, the testimony that you give will be valuable, and it will give a good opportunity for the other side to make a positive evaluation of how you would appear to a jury. Only answer questions that you understand. Again, that goes along with telling the truth and not guessing. You're the one that's under oath, so the attorney asking you questions, if you don't understand the question that's being asked of you, you can ask them to explain that. Maybe they can get some better question to you that you can answer. It's not your job to help them do that. It's just your job to let them know that you don't understand that question. And again, getting in the line of questions that ambiguity or things that can go the wrong way. Be careful about giving answers that can be misconstrued. Sometimes that's sarcasm or joking. During the deposition while you're under oath, that's not the time for joking or sarcasm. Again, those are things that can go the wrong way or be interpreted incorrectly. Now, typically the things that they want to know about you, or the things that they have as goals when they go into the deposition, is to learn about what you know of the facts and pin down your lack of knowledge about certain facts. Things that you do know and things you do not know, and how you learned those things. Now, the other thing that they may want to do are create admissions for use at trial. That is, you may admit that you did not see a certain thing before the collision. You may have already been injured in some way before the collision occurred. These are just examples. And if those are things that are factors in the case, the defense of this case, or the person that's asking questions of you in the case, may want to make sure that those things are things that they can later use. One of the other goals, one of the probably more favorite goals of the other side, and things that we like to do too, is demonstrate a witness's dishonesty. If somebody is bringing a case against us, if we can prove that they don't tell the truth about something else, maybe we can prove that they aren't telling the truth about our case. And that may be some goal that the defense lawyer may have in taking your deposition as well. We don't want to give them that kind of evidence. They may also be looking to find adverse characteristics. That is, maybe you're bothered by some of the questions and you begin to show anger, or maybe it looks like you're being greedy about what you're asking for. They may also want to demonstrate some weaknesses or strengths of your ability to give testimony. There are some people who do a poor job of recalling facts, or don't very well remember things that happened, or unable to articulate those things. They may want to look for those facts in your ability to testify. This is the reason that we're going through this preparation for you, so that you are able to give good testimony about the things that occurred and the facts in the case as you know them. This is probably one of the more common reasons for taking the deposition, because I think most cases aren't able to settle until a deposition is taken. So they may be taking your deposition in order to facilitate settlement. That is, once a deposition's been taken, or the other depositions in the case have been taken, the majority of facts that are going to be presented in the time of trial are known to everybody at that point. That testimony that's given in the deposition could be played back to the jury. So we know what everybody's going to say at that point. Other than that, they could be used to support motions for summary judgment. The deposition may be used to provide some foundation for some other evidence or for some other witnesses. They could be using the deposition to demonstrate the existence of other witnesses, documents, or other evidence that they may want to do additional discovery about. Sometimes there will be questions about records that were kept, recorded statements that were taken, or things along that nature that may lead to the discovery of other items that could be important in the case. They want to develop information about experts. For example, in your case, it may be doctors that you've seen or other experts that you might have visited with in order to help us develop the facts in the case. They may ask questions about what those people might have said to you to learn about what that testimony from those other experts might be without actually getting to that part of the case. Again, that's kind of a continuation of asking you questions to learn about what other discovery might need to be done or what other evidence that there might be out there. Further, they want to do some background information discovery, learn more about you, who you are. Lawyers want to learn about that. They want to learn about who's going to be able to tell the jury things that are important in the case and who can reach conclusions in the case. They're going to want to ask you questions about that to learn about what you do know and what training you have. Now, at the deposition, the people that are going to be there, obviously you will be there if your deposition's being given. Your attorney, depending on who's actually representing you, I get to defend you in your deposition. Of course, the other attorney who's taking your deposition will be there to ask you questions. Typically, a court reporter will be there. Sometimes I mentioned a videographer is there to videotape the deposition. There may be other people that can come to the deposition. It's less common, but it's possible that the other parties in the case may be present. The attorney might bring some support staff to help him in organizing his deposition. Sometimes I'll bring another attorney from my office to observe the deposition to learn more about that. We'll discuss that if that's something that would be happening. Sometimes an adjuster will come to the deposition, or sometimes an expert will come to the deposition. These are all things that are very rare, but do occur from time to time, just to know about. Now, the general outline of a personal injury deposition, typically an attorney that's taking that deposition is going to start out by giving you some ground rules. Those are, for example, that you'll go over the oath that you had given. They'll say, you understand the oath that you had given is the same as if you had been down at the courthouse in front of a judge and jury, only it's here in your attorney's office. It bears the same pains and penalties for perjury. That's the importance of the oath. You're going to tell the truth. He'll probably ask you about whether or not you understand that verbal responses are important in the deposition. And really, these are all things that are good for making sure that the record is easy to understand or readable later on. Sometimes they'll have some information about breaks. From there, that the attorney will typically get into some background information, more or less who you are, what you do, and what experience you may have. From there, they'll either get into the liability, that is what caused the negligence to occur, or they'll get into the damages. That's typically the injuries or the treatment that followed the injury. So liability, if they start that way, it'll be the facts leading up to the injury or the collision that caused the injury. Who was there, what was there, where, and sometimes why. Where were you going to, where were you coming from, or some common questions. What did you see? When did you see? Those are things that you'll probably hear in that part of that phase of the discussion in the deposition. From there, you'll get to injuries, and that's what was hurt. What did you understand to be hurt? What did you feel? Did you lose any time from work? Have you been unable to do certain things that you could do before the crash, before your injuries? They'll ask about doctors and hospitals, who you saw, what they did for you, and sometimes what the cost of those things were. Sometimes there will be a question about what you're looking for. Sometimes that's designed to be a tricky question to get you to commit to some large amount of money or to get you to commit to some very small amount of money and then later use that against you. Typically, what I want you to say about something like that is fair compensation for your medical bills and other harms and losses that you experienced, to have those things be dealt with fairly. You may, from time to time during the deposition, hear me make an objection to a question. During the deposition, there are only a few types of objections that can be made. So the objection that you would probably hear me make would be objection form. And that means that I'm objecting to the form of the question that's being asked to you. There are a number of reasons for that objection. And the reason that we use the word form instead of the actual objection is because that would be coaching you. For example, if I were to say, objection, speculation, you're making him guess, you would understand that the question is designed to make you guess, and then you would be a lot more careful about answering that question. If the objection to the form of the question is made, understand you still have to answer the question as best as you can. If for some reason the other side disagrees with the objection to the form of the question, or they may ask for the basis for that objection, and then in that time I can say on the record what my basis for the objection was. The only time that I can really coach you, or the only time that you can consult with me during the deposition, is if there is a question of a privilege. That is probably some conversation that you and I had, or you and somebody at the attorney's office, my attorney's office, had with you about the facts in the case. Those are times that you can ask me, hey, is this a question that leads to that discussion? And if that's a privilege that we have, we can use that conversation to claim that privilege. These are pretty rare. Most attorneys are going to tell you they don't want to hear anything about any conversation that you had with your attorney or anybody else at your attorney's office. There may be other reasons for a privilege. For example, if it was something to deal with your work and it concerns some trade secret privilege, or if it concerns some other maybe diagnosis or conversation about some other person that may have nothing to do with the case, we can consult about those things. But again, those are very rare, and I don't get those types of things very often. There's a list of reasons for objections, those things that replace form. Now, as you receive each of the questions, I want you to be listening to the question that's being asked of you. Pay attention to the words that you're being asked. I want you to think about the question. You don't have to spend a lot of time thinking about the question, but just a moment to make sure that you know the question, or you know what the answer to the question is. This gets in the line of making sure that you only answer the questions that you understand, and making sure that you give answers to questions that can't be or you don't misconstrue the questions, and that your answers match the question. Once you are sure that you understand what the question is, you know what it is, and you know whether or not you know the answer, give a truthful answer to the question. And if you don't know the answer to the question, the truthful answer might be that you don't know, or that you don't remember. Those are perfectly okay answers. Don't feel bad about giving something. This isn't a test that you're going to be scored on, and if you don't know the answer, you're not going to get a point. That's not the way that this works. Now, one of the things, I'm going to show you a slide here that shows a little bit of testimony, and this kind of tracks the question and answer. This is just a little bit of background information that I asked of this particular witness, and he did a good job of answering the questions that were put to him. For example, I asked him if he'd lived in any other cities besides Austin while in Texas, and he says, no, only Austin. And just right to the point. You can see that goes on for a little while on this page. You also can see that the layout of the transcript, when the deposition is completed, the testimony is placed in a book, and each page is numbered from the top to the bottom with questions and answers, questions being asked and answers being given, with the Q&A down there. It may also look familiar if you've ever read an interview. Think about that, and make sure you keep your testimony that way too. I also want you to see that there are also not very good ways to answer questions. For example, this is a deposition that I was in, and the question was asked, did you lose employees at some point? And you can see that there on line 20, the question was answered. No, never lost anybody. But the witness in this case went on to maybe give a lot more information about what was not really related to the question at all. Certainly, it demonstrates that that witness wasn't listening to the questions and is not focused on giving the answer to that question. Probably what was happening here is the witness was thinking about what the attorney was trying to get at with his question and went ahead and gave him that information. That's not the right thing to do. Sometimes those things can come back to haunt you. Sometimes those things can go very wrong. So I don't want to feel like you have to give the why to the answer to any question, which is kind of what this is. I want you to just answer the question that's being asked of you. I also don't want you to be too limited in the answer that you don't fully answer the question, but certainly don't over-explain your answers, or don't feel like you have to explain your answers. As perfect is the enemy of good. Don't feel like you have to think of the perfect answer. If you've answered the question and you've answered the question truthfully, it's good enough. Nobody expects perfection in this. Good is good enough. There's some tricky questions I want you to be aware of, and I've grouped these into some different categories. For example, the misquote. You said earlier you were stopped for a minute, weren't you? And if you're encountered with something like that and it doesn't match what you'd said earlier, here's an example of something that was in another deposition. The witness said, no, I said I was stopped for about 1 to 3 minutes. Making sure that the testimony that you swear to is correct and consistent with the earlier testimony that you gave. Now that's something that was probably also objected to, but the answer that the witness gave would have been fine to fix that problem, even if the objection wasn't made. Sometimes there's an implied answer, that is, you didn't actually see the man clearly, did you? So there might not be something that was. This is kind of a leading question. There may be something about the facts of the crash leading up to the point, either or maybe somebody at the scene that you may or may not have observed. For example, if the answer that the attorney implies to you is incorrect, address it right away. For example, this witness said, I saw the man very clearly. There are some tricky questions that are designed to imply something that you might know. For example, this is one that was given to an accountant, something that might have been part of that person's expected knowledge. And the way the attorney put it was, well, as an accountant, didn't you know what was posted? Well, maybe the accountant should have known what it was, but the accountant did not, in fact, know, and so truthfully answered, no, I did not. Don't feel pressured by somebody who might be trying to push some expectation on you. Sometimes questions will come out of sequence. There may be, I think this was another accounting question, and it said, did you use the most recent standards? Well, at the time of an event and the time of the deposition, most recent might be different things. And this witness was aware enough to say when, at the time that the decision was made or now. Sometimes questions will be personal questions. These sometimes do get uncomfortable. You'll have to assume that the defense lawyer or the other person taking your deposition knows everything that's ever happened to you in your history. For example, this question, didn't you have an abortion, a DWI, a felony charge in the last year? If that is in fact true, answer truthfully. If there's a reason for me to object and protect you from that, I will do so, but those typically aren't things that are excluded from their ability to do discovery on you, and those are questions that you probably will have to answer. Sometimes a question may come across as scolding. For example, couldn't you have provided better warnings? I think this was probably one more for a products case in which the defendant was supposed to provide a warning about the product, the dangers of the product. And the answer that the defendant gave was, I believe, we provided good warnings. Well, that's good testimony. Those are things that are designed to make somebody give in or designed to push the witness. Don't feel pushed by that. Keep it to the truth. A couple others that you might hear. This question comes in the form of have you ever? Have you ever? It implies a very long period of time. For example, have you ever seen a doctor about back pain? If you have in fact seen a doctor about back pain prior to the doctor that you saw for injuries involved in the collision that you're being deposed upon, well then obviously that's a question that's easy to answer. Where it gets a little bit more difficult is if you don't recall ever having seen a doctor for back pain and I don't expect you to know the contents of every doctor's record that you have ever visited. And the reason I bring this up is sometimes what somebody will do is ask you this question and then go and collect all of your past records and find maybe one or two indications where you went to see a doctor about something else, maybe a cold, and you told the doctor, yeah, my back hurts a little bit, and that showed up in your medical record. That may be something that's used to later on say, well, look, you've complained to your doctor about back pain before, despite what you testified to in your deposition. And those are things that are used to kind of add up as inconsistencies. I don't want that to happen to you. So instead of answering something like that, unless you absolutely know that you've seen somebody or absolutely have seen every medical record ever produced for you, say, I don't recall ever having seen a doctor about back pain if you don't in fact remember doing that. Vague questions. Were you there long? It wasn't short, was it? I don't know what their idea of long is. I'm not sure what their idea of short is. You might ask them to be a little bit more specific about those things if faced with those questions, or just let them know that you don't know the answer to that question. Sometimes you'll be asked a non-question. These are questions that really don't have there's no question mark at the end of it. It usually comes in the form of a statement. Typically what they're trying to do is get you to adopt some testimony. For example, of course the accounts are kept in the safe. Well, that's a statement. If that's been asked of you and you're not sure if it's a question or not, you can say, I'm sorry, what is the question? Or you can just wait for them to get to the point of asking you the question about that statement. That might be something that also comes up with the next thing. Silence is a pretty effective tool to get people to talk. Most people in the situation are a little bit uncomfortable. You may have a little bit of anxiety. And some people feel that they can fill the air with talk, and that makes them a little bit more comfortable. Don't let that happen. If it's silent, understand that that's being used to make you feel awkward and to get you to talk more. Just be silent until you get another question. It might also be a good time to ask for a break. Where are we going with all of this? Well, the deposition testimony is part of the usable evidence in the case that I mentioned earlier. Once the jury has seen and heard all of the evidence presented in the case, they make decisions about negligence and damages. I mentioned those earlier. The things that we will say will be argued in support of those questions. So we need to make sure that we understand that the testimony that we give is going to be possibly a factor in those things in the case. And these are the things that will be used to make decisions about what to do in your case. I'll put up a copy of the question that a jury sees in deciding whether or not negligence is present in a case. Usually they're asked, did negligence, if any, of those people named below proximately cause the occurrence or the injury in question? And this is, for example, one from a premise case, but you see the idea. Those are things that evidence that's put together from the testimony of a witness, either you as a party in the case or somebody else who observed the facts in the case, are used to answer these questions. Those are the evidence and the facts in the case that the jury can make determinations from. There's some definitions about what negligence is. I'm going to give you a copy of those things so that you know that for your information and knowing about the way that this case progresses. The other part that they're going to answer is questions about damages. These are the past pain, the mental anguish, loss of earnings, disfigurement, physical impairment, and medical care expenses incurred in the past. Now, a lot of these things are typically answered with other evidence. For example, the medical care expenses incurred in the past, those are things that we can usually point to the medical bills for. Medical records explain those things. Probably one of the most difficult of those to answer is the impairment, and that is things that you couldn't do that you could normally do but for the injuries that you sustained in the crash or the event. And that between now and the time of your deposition, that's really something that I want you to think about. For example, were you unable to do laundry? Were you unable to do shopping for the family, cleaning around the home? Did things take you an additional amount of time? Were there certain hobbies that you couldn't participate in because of your injuries? Make a list of those things. Those are things that we tend to adapt to those jobs very well, and we don't remember exactly what we were doing before the crash unless we think about them. In the time of the deposition, if you're put on the spot about something like that and you hadn't had a chance to think about them, it's hard to remember what you might have done. Your deposition is going to be held at typically at our office, but I'll give you that information in a separate form. Typically, I want you to be here before the deposition, about 20 to 30 minutes before the deposition's noticed. Know that you can give me a call. You can send me an email anytime to ask me questions about that. I just want you to feel informed about it so you have a good idea of what to expect, and give us some time to get to some more of the specifics of your case. Thanks for watching. I appreciate your time and attention.